Good afternoon, everyone. Welcome to this webinar series organized by the Isam Ferris Institute, the Energy Policy and Security Program. So we are happy today to host this discussion about the maritime borders dispute in the Eastern Mediterranean. And the reason we have decided to organize this discussion is we have many reasons for those which I'll try to introduce briefly. So the Isam Ferris Institute has been working since beginning of this year, and we have published a paper March 2020 on how to unlock peace and prosperity in the Eastern Mediterranean and how to resolve the maritime borders disputes in peaceful ways. And with this being said, and everything that happened later on, several updates have been ongoing during the summer of 2020 in the Eastern Mediterranean. So the East Med and the latest development in the East Med have been focusing lately on the updates, or if we want, military updates between Turkey and Greece. But recently in October and 2 weeks ago, another update has been added to this list, which is the kickoff of indirect negotiations between Lebanon and Israel concerning the Southern Maritime disputes, and which has taken place after decades of disputes over those. So we will try to today in this panel, in this webinar, to answer as much questions as possible and to tackle those disputes when it comes to law and science. And I'm happy to have among us today in this panel Mr. Rudy Baroudi, who has been contributing to this paper, the paper that the Isam Ferris Institute has shared. So Mr. Baroudi is an energy expert and an energy economist with around 40 years of experience in the international public and private sector knowledge in the oil and gas sector. Also, he has been involved in several power, energy, security, and infrastructure and privatization projects. He has several and many publications, numerous articles, and books on the political, economic, and climate change matters when it comes to energy. Also, I am happy to welcome Dr. Charles Elinas, who has just joined us on the panel. So welcome, Dr. Elinas. Dr. Elinas is an oil and gas consultant with over 35 years of experience in the oil and gas sector. Currently, he is the CEO of EC Cyprus Natural Hydrocarbons Company, providing management and services in the oil and gas and energy sectors in Cyprus and the region. So prior to being the CEO, he has been also involved in Critic. He was responsible for the implementation of Cyprus government strategy and the development of its hydrocarbon sector. So previously he was with McDonald's for 25 years, and he is also featured as editor at Natural Gas World, and he is currently a senior associate at the Atlantic Council. So welcome to this webinar, Dr. Elinas. And also we are pleased to have with us Dr. Naomi Campbell O'Sullivan, who is the legal officer at the International Tribunal for the Law of the Sea. So she's been there since 2016, and prior to taking up this position, she was
Naomi Burke, not Naomi Campbell. Naomi Burke. Naomi Campbell is a different.
Naomi Burke
in fashion. Right. She's in fashion, and thank you.
So prior to taking up this position, she was at Erdowatt Research Fellow and for the Law of the Sea at the British Institute for International and Comparative Law. She has also worked as a Judicial Fellow at the International Court of Justice. So we are happy to welcome you as well on board of this webinar. So just briefly, and before we kick off the discussion, I wanted to, if we want, put things into the perspective. So the Isam Ferris Institute paper and the Energy Policy and Security Program's paper has tried to answer several aspects of the disputes, of those maritime disputes, to explore the key legal, scientific, and also technical perspectives of those disputes. We will try today to discuss the future pathways of those current military escalation and tensions and the related security dimension, and to propose internationally well-known and recognized mechanism for those disputes. To start with and to kick off the discussion, I will start with Dr. Elinas, who I think he might not be able to continue with us to the end of the session. So we'll try to benefit.
In fact, I can't continue to the end now.
Yes, that's great. So we'll benefit from your presence in the Q&A as well session. So you have several publications over the past month regarding the dispute happening in the East Med, specifically when it comes to Turkey and Greece, and also its impact on Cyprus. So I would like to start with you and ask you two main things. First, what is your overview about the overview about the situation and the military tension happening in the East Med? And since you have been involved for the past years in with international oil companies, and you have this, if you want, economic perspective of that. If you can tell us also, after like putting the overview and setting the scene, what are the implications of such disputes on the exploration and development activities? And I can like quote you on something you have written very recently, saying that the exploration or drilling in the East Med is unlikely to resume for a while now, maybe not earlier than 2022. And East Med gas is likely to continue to be too expensive to explore commercially. So I would like to start with that, get your insights on the overview, geopolitical overview of the situation, and tackle this economic perspective of the East Med dispute. The floor is yours, Dr. Elinas.
Thank you, Mark. In fact, I have a PowerPoint presentation to form the basis of my presentation. And I'd just like to say that, as you said earlier on, my presentation will go a bit more deeply into the techno-economic aspects, and it blends well with Rudy presenting the EZ disputes and problems, and Naomi coming and telling us how perhaps you can solve these, what vehicles are available to us to sort them out. So let me go into my presentation. So let me go to the next one. So within the East Med, COVID-19 has had a massive impact in terms of drilling for gas in the East Med. It has also affected gas development in general. So, for example, around Cyprus and Lebanon, all activities to do with oil and gas have come to a stop. The global gas industry was in trouble due to overproduction of gas and LNG, and not sufficient demand developing globally much before COVID-19. The pandemic made it much more difficult. The economies of all countries around the East Med have been affected quite badly by COVID-19, and recovery will be difficult and challenging. So let me just go through some of the general aspects of the issues, and I will support these by graphs in a minute, by charts. The East Med EZ disputes abound. There is a hodgepodge of claims and counterclaims, and it's not. And I will show you some of these, especially those that involve Turkey, Greece, and Cyprus. Natural gas is often used as the excuse for these disputes, but for certain it is not the driving factor, especially in the dispute between Greece and Turkey. Resolution is only possible through discussion and negotiations, not through confrontation and coercion. Confrontation and coercion will not lead to anything but maintaining the problems rather than solving them. Resumption of drilling may be delayed until 22 and very likely after that because of the state in which the international oil companies are. This met gas is expensive to produce. It's deep water and deep reservoirs and quite difficult to produce and expensive, and without infrastructure, it makes it even more difficult to put in pipelines or liquefy and export. Last week, the International Energy Agency, in its annual World Energy Outlook, specifically warned that higher cost development projects are increasingly difficult to justify simply because of this transition to clean energy. And this, the IEA said, includes this met. So it's very positive about our prospects. It is difficult to secure sales in global markets because of low prices and high cost in this met. The global gas and LNG markets are oversupplied and will continue to be oversupplied for a long time. And I will show you why. As a result, prices are low and will stay low. Europe does not need this met gas. Europe has migrated to green energy, and I'll tell you a bit more about it later on. The future for this met gas is regional, local and regional energy markets. Gas could be used as baseload, unlocking renewables, of which we have plenty, especially sun, and we are not actually using. So there is a huge potential to use renewables in the region. This is a map produced by Bloomberg, and it shows the claims and counterclaims and the hodgepodge of lines everywhere. And each one of those is justified using, inverted commas, international law. Even Turkey claims it's using international law to justify its own claims. Solving these is not going to be easy. And this is a cartoon by The Economist, which is quite apt. So when Turkey says it uses international law, in fact, it interprets international law in a unique way, its own way, contrary to everybody else. And that's what makes the resolution of the disputes very difficult. This is a graph of LNG supply and demand produced by Bloomberg. And the red line shows how demand for LNG will develop over the next 20 years. And you can see from this that in the period 2020 to 2030 approximately, there is going to be much more LNG in the market based on projects already in existence and declared, not new planned projects. Too much LNG in the market in comparison to demand. And when you have too much of something, prices stay low. And after 2030, all bets are off because the global energy picture is going to change dramatically because of transition to clean energy. So over the near term, between now and 2030, we are in trouble. Prices will be low. How can we export to these markets? They are not going to pay us. And the oil companies will not develop the gas if they don't have sufficient margins. And just to show you the crisis in which the oil and gas companies are, this is the annual spending by international oil companies in projects and in operations. And you can see that in the good days up to 2014, spending was increasing rapidly and it reached $750 billion by 2014. Then we had the collapse of oil prices between 14 and 15, and prices and spending went down dramatically. And then we had COVID-19. Spending now is barely 40% of the peak at 2014. That 40% has to cover ongoing operations, ongoing production and exports, as well as new exploration and production. How can it cover exploration and production? There is barely enough money being spent on maintaining operations, let alone spending more on new exploration and new production in frontier areas like these met. it's very difficult. And even though McKinsey expects this to increase somewhat as the industry recovers, and you can see from here the recovery isn't going to be complete until 2023, 2024, that spending is still a lot less than spending in 2014. That makes it very difficult. So, East Med Maritime dispute, let's go back into that. Greece-Turkey confrontation has reached dangerous levels. Until recently, with German mediation, there were hopes that the dispute was on the way to be diffused. But Turkey has sent its drilling rig back into the disputed area in October, and it scuppered discussions, which are now frozen. They're not talking to each other, Greece and Turkey. It's not clear what Turkey is aiming for. Could it be to divert domestic public opinion? The economy of Turkey is in debt trouble. The lira has collapsed almost. The value of the lira is dropping day by day, and its GDP is 25% less now than its peak. So there is a view that Turkey is creating all of these conflicts and getting involved everywhere, having problems with all its neighbors, as far as Armenia now and Azerbaijan, to divert internal domestic public opinion away from these problems. And it has actually worked to a certain extent. In September, Erdogan's rating, following the disputes with Greece, actually went up. So there is some credence into that. But as I said before, is this a meaningless situation if gas exports are not going to be viable? Are the two countries fighting windmills? And for the reasons I showed before, and the fact that in the area of dispute between Greece and Turkey, indications is that there is no gas, hardly any significant amount of gas are present in that area. Turkey has drilled up to now 7 wells in the East Med, and it has found nothing. So gas is not the driving factor. Other reasons are behind the dispute, not gas. Everybody keeps talking about gas, but it's not the reason. For me, the time has come to find a way to bring the two countries away from the brink of confrontation, back to negotiation. And if needed, to refer it to international courts. And I hope that Naomi will tell us a bit more about this, how and what we need to do getting there, to make sure that we actually get there. As I said before, the international oil sector is in crisis worldwide. The first half results of 2020 results show massive losses. I mean, one of the biggest new protagonists in our area is Chevron. The losses of Chevron in July were $8.5 billion. Massive. So how can Chevron go and invest more money to discover new gas fields when it still needs to recover these losses to maintain its operations and its dividends? As a result of this, the IOCs have announced 20 to 50% spending cuts and staff cuts in 2020 and more in 2021. And as I said before, restructuring reconsolidation is taking place and may take 2 to 3 years to complete. The European IOCs, Shell, BP, and Total, and Eni, and others, are transiting to renewables. They're making huge commitments to transit their operations to renewables. In fact, BP said that by 2030, it hopes that it is not just hopes, it plans that 40% of its operations will be renewables. The IOCs are going for large, as a result of all of these things, as a result of the need, even with very low oil prices at $40, $50, to produce profits to maintain dividends, because if they don't maintain dividends, their shareholders will leave them and they will have more trouble. So to maintain these dividends, they want large profits. So they're going for large projects, easy to develop, and high returns. Where this is not the case, they divest the assets. EastMed does not fit into this. We don't have large projects, and certainly the returns are not going to be there. That's why I see problems with EastMed as far as the international oil companies are concerned. I will rush a little bit because I'm taking too long. But as I showed before, global markets and prices are not are not favorable for us. Globally, LNG is excessive. There is too much in the market, and there is more coming into the market. And as a result, prices are low and will stay low for a long time. The big factor that is affecting us and is the future is environmental. The world, with Europe in the lead, is steadily but surely going greener. EU's Green Deal will start impacting gas demand by mid-2020s. And you probably heard that the EU is now about to raise its carbon emissions cut to 55% by 2030 from 40%. They cannot do that by burning gas as they have been burning in the past. That's why gas demand is going to be impacted. And beyond 2030, it's going to be less. And given that a project, once you develop a project, it takes about 20 years of operations to recover your costs, your investments, and make profits. So if a project take Aphrodite, we keep talking about it in Cyprus. Even if they start now, it will not be producing until 25, 26. And then beyond that, it needs to be producing and selling gas for 20 years to recover the investment and profits. Is that possible? The answer is no. The markets are not there and will not be there. This is the challenge you're facing. Europe has all the gas it needs and does not need any more large import gas pipelines. And this EastMed has abundant renewable resources. So the future for the EastMed is to actually use the gas regionally in conjunction with renewables to bring emissions down and produce cheap energy to help our people. I mean, Cyprus, unbelievably, the industry in Cyprus pays the highest electricity cost in Europe. How can it be? If we move from petroleum products into gas and into renewables, prices will come tumbling down, and that's what we need to do. So, unlocking the future, this EastMed should, with exports to global markets becoming difficult, we should take a more realistic view of the future of EastMed gas. Greece and Turkey can give the lead to rapprochement post-COVID-19. Both countries must lift their economies. They can do this only by eliminating conflict through negotiations or referral to ICJ if required. Such a development could also help Cyprus concentrate on solving the Cyprus problem, decoupled from unrealistic energy aspirations, which appear to be coming or making the negotiations and discussions more difficult. If you throw that out and concentrate on the problem, maybe you have better chances to resolve it. For EastMed gas, the future is local and regional energy markets with emphasis on renewables. Thank you. Mark, I hope I answered your question.
Thank you so much for setting the scene, Dr. Elinas. Thank you for those insights. And I'm just to wrap up what you have mentioned, like we are in a difficult situation when it comes to gas markets, to gas situation, and it became worse with the COVID pandemic and the EastMed. So we are saying that we're going to reach the demand peak at the end of this decade in 2030, and you have mentioned something very important, like saying that gas is not the driving force of those disputes in the East Mediterranean. And I want to kick off from this point to move to Mr. Baroudi. You have worked extensively on discussing the technical and legal aspects of those disputes and seeing based on law and science on how to unlock peace and prosperity and reach peaceful negotiations and peaceful resolutions for such dispute. So kicking off from this takeaway from Dr. Elinas, that if the gas is passing through a difficult era in the next decade. We have heard in August, and there was a collision between the Greek and the Turkish navies in the East Med regarding exploration activities, and this have also led to the diplomatic participation of the United States, Russia, France, etc. So I would like to take it off from here and ask you, like, regarding, if you can kick off from this point and to go through the paper directly, how can we unlock peace and prosperity in the East Med? Taking those examples between Greece and Turkey, and later on Lebanon, Israel as well, into consideration, and how can we abide by what the law and the science tell us when it comes to those maritime disputes? So, Mr. Baroudi, the floor is yours.
Thank you very much, Mark. And I want to thank, first of all, the AUB and Isam Faris Institute to hold such a virtual forum, which is very essential during this COVID-19 pandemic. Whatever Dr. Charles Elena said, it is something very good. He has put all of the points as they should be, with a empirical facts of what we have in the East Med, from the IOCs to the East Med needs for Europe. As you probably know, it could be around 10 to 15 cubic meter per year, while Europe needs is around 500. So Dr. Elinas is completely right. It's a very small pint in the barrel. It could justify some excess lining, to come from outside the normal routes. Now, Mark, if you can show, please, the East general map that you have for the 8 Mediterranean countries, that I will give you a small appreciation about this. In this map, this is a study for the last 3-4 years. Started conducting it in 2017 for the 8 East Mediterranean countries. No, if you go back to the first one, yes, to this one, yeah, Mark, thanks. This shows from Libya east to Israel, Lebanon, Syria, Turkey, Greece, Egypt, and Cyprus. For the time being, if we talk about the Mediterranean Sea as a whole, the Mediterranean Sea is 2.5 million square kilometer zone. The East Med here, we are talking about 875,000 square kilometers. And in these 8 countries, the official boundaries that are recognized by the United Nations, and they are already submitted and filed at the Division of Ocean Affairs, are only the ones between Israel and Cyprus and Egypt. Even though 3 months ago, Greece and Italy, they have signed off, they have sent their coordinates, but it is not an official maritime boundary signed. So if you look at this, you see the red dotted lines everywhere. And this is where the maritime boundaries who are still disputed or unresolved. To go back now to the next one, Mark, if you can, please. Yes, if you want to tackle for the local audience here, the problems between Lebanon and Israel. Here you can see at the bottom, the yellow triangle, the disputed zone of 871 square kilometers as the disputed one. Today and tomorrow, they will continue the 2 task force between Israel and Lebanon to coordinate with the UN and under US support to negotiate in order to come to a final settlement for this zone, taking into account that once we settle on this, if you see the yellow star on the left here, this is supposed to be the tri-junction point between Cyprus, Israel, and Lebanon. Once we have this, Lebanon and Cyprus could immediately also take the advantage of signing and finalizing a 97 nautical mile line between the south and the north, and sign the maritime boundaries with Cyprus, which is long awaited for after almost 16 years. This will also automatically fix the tri-junction point that is in the north, which is the tri-junction point between Syria, Cyprus, and Lebanon too. So this will facilitate that each country has its own blocks. They are already known. Like, as you probably know, in the Syrian side, you have the Soyuz Naftogaz there, who have their exploratory right for 20-25 years. Some of our blocks are inside these borders, and some of their blocks that are inside our blocks too. So that will delineate the. Now, let me go through the third one, which I'll explain to you the basis of the problems that we have with the Israelis. You will see here three small blocks on Israeli coast. If you look into the yellow line, this is the Ras Al Nakura line, which is the official armistice of 1948 point that was accepted by both parties in 1948 to have the ceasefire. So the two countries, we are technically in a state of war. So this is the no man's land. So if you consider that as Nagakura point, and you take the west side, according to the United Nations Law of the Sea, which Lebanon has signed, Israel did not sign. However, Israel, in their negotiations with Cyprus for their maritime boundaries, used the methods used by the United Nations Law of the Sea to demarcate an equidistance line between Israel and Cyprus. So there is a precedent there. So if there is a precedent there, those little rocks that show, and these are not islands, these are islets, they are inhabited, so they do not have the weight or the capacity to be considered as living islands in order to push the yellow line up north. And in the 871 square kilometers, there is an opinion of an oil and gas firm that along D, which is now block, I think, 74, apparently, according to their geologist, runs inside underwater the Lebanese border. So Lebanon could claim its right in a joint development agreement there too. And this is one of the reasons that this needs to be settled. We are grateful for the US that are assisting us and have been assisting us for the last 10 to 12 years to reach that. And this is in a nutshell what we have. This is on the this side. Now, if you want to go back to map one, I will give you a small word about Turkey and Greece.
Exactly. So just to intervene like here, two quick notes on that. So what, if you can, before moving to Greece and Turkey, if you can give us your opinion about the maximalist approach, like the Lebanon is trying now to tackle when it comes to beyond, as you have mentioned, like even the Alandi and including Karish, that Karish is part of the Lebanese waters as well. And two, when we move to this map again, if you can tell us more about the role of islands when it comes to the maritime delineations between Turkey and Greece, and like a few of them say it should have a full EEZ, it should be considered as full EEZ with 12 nautical miles, while Turkey is saying that no, it should be at 6 nautical miles and not 12. If you can also clarify this during this intervention. Thanks. Thank you, Mr. Bak.
Okay, Mark, if you can put the 3 islands map on, please. Yes. Now, to give you an example here, why the study that we came out with. Now, these pictures have been taken through a latest technology provided by Airbus Defense Satellite Imagery that takes a picture up to 90 centimeters from ground level. And what we did here is that we have searched through the International Court of Justice for the awards for the last 25 to 30 years. And we found, even before the UNCLOS and after the UNCLOS, we found the 3 compelling cases, jurisprudence, that the International Court of Justice did not give such islets or rocks the weight the Israelis are trying to push here. Basically, number 1, there is the ICJ ruling between Myanmar and Bangladesh. The second ruling is between Nicaragua and Honduras, small islands like this, small rocks like this. And the third one is between Tunis and Libya. So these are compelling cases. So if we go to the International Court of Justice, we are very hopeful that we are going to get much more than the 80% and not 52% like they are claiming now from this disputed zone. Now, if you want, we can go back to Turkey and to, for Turkey and Greece, I entirely agree with Dr. Elina, whom I've known for the last 10, 12 years, mature, solid thinking. We should all avoid war. We should all profess and disseminate knowledge that any negotiations here have to be based on a goodwill basis. United Nations Chapter 33 calls for to use all of the means for a peaceful resolution of any dispute. Number 3, Turkey and Greece, they have to face their enemy, and their common enemy of Turkey and Greece is their past. The past of 1923 and the past of Paris 1948. It is not those 2 leaders that have created. 2 strong-willed leaders, the Greek Prime Minister and the Turkish President Erdogan, they have to face their past. They have to kill the enemy. The enemy is the past. They both have vast seashore. Turkey alone has 1,600 kilometers on the Mediterranean seashore without counting the Black Sea. They are there. They are 82 or 83 million people. They are neighbors with Greece. In the last 300 years, they have had 4 wars. We don't need war to do that. Today, with the precision mapping, the goodwill, and there is a committee that was established in 2010, the High Executive Government, Turkey and Greece Committee for Dialogue is there. They can meet, they can settle, they can shake hands. And like Dr. Elinas in his beautiful PowerPoint presentation, that will immediately entangle peace on the Cypriot Islands. When Turkey and Greece settle in their difference, they will go there. Greece last week declared that with Albania, they are going to go to the ICJ. can't we do the same thing here? The answer is yes. So if there is more than the gas, that's, I do not know. I am, I'm just going to stick to the oil and gas. Now, the Castellarizo example, according to certain legal advisors that I have worked with, the Castellarizo Island has been compared like the Channel Islands between France and the UK. The Channel Islands are around 6 miles from the fresh Normandy coast. The ICJ ruled 6 and 12 miles. They did not rule for the Guernsey Island a continental shelf. Now, I might be wrong, but that's what the book says. And the best way, instead of going with more ships, to explore here and then there, the meeting, the high committee meeting between Greece and Turkey, they can sit down, they can have a team, go to The Hague and file for consultation. The International Court of Justice is a platform to assist government to sit down and speak peace. World War II is done. We can no longer have another war here. The area is too small, and if we bring peace, everybody wins. If we have war, everybody loses.
Thank you so much, Rudy, for those powerful messages and technical remarks on that. So now that we have listened to the technical and also economic perspectives, we will move to the legal. And this is why we have Dr. Naomi Burke with us. But before that, I would like to just mention for the attendees in this webinar that we are going to fix, at the end of the session, some time to Q&As to the panelists. So please do send your questions in the Q&A box here on Zoom. Or if you are watching us on Facebook Live, please put your questions in the comment box, and I will be happy to tackle them once we're done after the discussion. So Dr. Burke, everyone is pointing out to the International Court of the Law of the Sea and the role of the IGC in reaching solutions to such disputes. So we'd like to know more, if you may allow, if you can tell us more about the role of the court, and when can countries go to the court, and how could we, with everything that has been mentioned previously by Dr. Elinas and Mr. Baroudi, what would be the solution of those conflicts? Before asking you more into technical or legal questions on that, so if you could clarify what would be the role of the court, and give us some examples of previous disputes and how they were managed.
Yeah, okay. First, I just want to say thank you for the invitation. It's a pleasure to be here, and also to congratulate Mr. Baroudi on the report. I thought it was really excellent, I think, because it combines legal, technical, and political aspects. And often in my field, we read only the legal side of things, sort of separate from the political environment. So I don't want to give any views on substantive questions of delimitation or how to solve a particular dispute. I'd like to just more broadly talk about, firstly, negotiation of maritime boundary agreements and the legal effect of maritime boundary agreements. Then to talk about judicial settlement, delimitation by an international court and tribunal, and what the options are for states in terms of the different bodies that are out there. And finally, just to quickly mention rules that would apply pending the delimitation of a maritime boundary. So states that want to delimit a maritime boundary with a neighbor, they can choose between going for a negotiated settlement through bilateral diplomacy with the other state, or to go to an international court or tribunal. Often the path that states follow to court or tribunal is to first try negotiating, and this can take often many, many years. They reach a stalemate and it becomes apparent that they cannot agree, and at that point they decide they will submit their dispute to an international court or tribunal. In terms of negotiations, the only rule that we have under the United Nations Convention on the Law of the Sea, which I will call UNCLOS, is that states should reach an agreement on the basis of international law. That's all it says. That's the only guideline for states. This reference to on the basis of international law, through the practice of courts and tribunals, that has been taken to refer to this three-step approach, where states basically first draw an equidistance line that's halfway between each state. Then they modify the line to take into account particular circumstances, and then they check that the distribution of the areas at the end is proportionate. The advantage of bilateral negotiations for states is they have more flexibility in how to apply the rules of international law. So they can come up with whatever unique approach they think is right for a particular situation. For example, they could decide to give more weight to a small island feature that the law of the sea would generally call for, or they could decide to have a particular solution for an area of hydrocarbon resources. States are free to depart from particular rules of international law in their bilateral negotiations because only those states are bound by the agreement that they reach. And just normally this agreement is in written form where they agree to be bound, and it's signed by members of the two states who have the capacity to bind those states. So on the legal effect of boundary agreements, an agreement between two states cannot affect the entitlements of a third state. It cannot have a legal effect. There may be some practical issues for that third state. And I think you read this in the press a little bit, you know, state X has just made this enormous claim or concluded this agreement, and what does that mean? Are they stealing the entitlements of somebody else? But that's not really how the law of the sea works. It's not a first come, first served basis of entitlement. The entitlements are based on legal rules. They flow from land territory. And just because two states have an agreement that they will split up an area in a particular way, that doesn't have a legal effect on the interests of a third state. I also want to mention what happens after two states have reached a bilateral agreement. And there are basically two kinds of obligations they have afterwards in terms of what they do with that agreement. I just share my slideshow here. Sorry. Okay, sorry. Apologies. Okay, so the two types of obligations I wanted to mention, the first one is registration of the agreement. So that's under Article 102 of the Charter of the United Nations. So this applies to member states of the United Nations. Anytime they conclude an agreement, they have to register it with the UN. And this rule has its origins in the League of Nations, and this idea that there should be no secret diplomacy and no secret deals, and everything should be known to other states around the world. And the sanction for states that do have a secret deal or who don't register their agreement with the UN is that then they cannot rely on that agreement before an organ of the United Nations, including the International Court of Justice. So if they have a secret deal and then one of those states violates the agreement, they cannot bring a case to the International Court of Justice because they have not registered that agreement. Then, particular to the law of the sea context, for a maritime boundary agreement, states also have publicity requirements under the law of the sea convention. They are supposed to send agreements with a list of geographic coordinates to the Division for Ocean Affairs and Law of the Sea of the United Nations. And then that division publicizes these coordinates in a bulletin that's circulated to all states. And the purpose of this due publicity requirement is to put other states on notice of the claims of states. So, for example, a state gets notice of an agreement or a declaration of an EEZ, and it might disagree with the base points that that state has used. And then it can register its protest or its disagreement. And you see this on the website of the Division for Ocean Affairs and Law of the Sea, all the letters that are sent in by states in protest to the publication of agreements or national legislation by other states. because even though third states are not bound by these agreements, there's a possibility that if they didn't protest, they could later be said to have agreed by acquiescence, and some weight might be given to the fact that they didn't protest. So we have in due publicity a kind of a notification and protest arrangement. So that's just what I wanted to mention on negotiated boundary agreements. And now I'll turn to settlement, judicial settlement. So states have two main options, two types of options if they want to go to an international court or tribunal. The first is permanent bodies. So that is the International Court of Justice in The Hague and the International Tribunal for the Law of the Sea in Hamburg, which is where I'm based. So these bodies pre-exist, the judges have already been elected, they have fixed rules of procedure. The other option is that states can go to a tribunal that's been created only to hear their specific dispute. And they can do that either under the Law of the Sea Convention, it's called an Annex 7 arbitration, or they can create an ad hoc tribunal just based on their own agreement. They can make up the rules between themselves, how many people they want, how long it would take, and what kind of issues that ad hoc tribunal could deal with. An example is Slovenia and Croatia, who signed that kind of arbitration agreement. They wanted an arbitral body to settle both land and maritime boundary issues. Eventually, that did not turn out to be a very successful arbitration because there were some issues. There was some leaked information, and which led one of the parties to lose confidence in the tribunal. But just to give an example, that states are free to create their own kind of tribunal. The main thing to emphasize in terms of recourse to an international court or tribunal is that you need, for the most part, the consent of the states concerned. So under the Law of the Sea Convention, states are obliged to submit their disputes to an international court or tribunal. So this sounds great as the general rule, except there's an exception that they are allowed to say that they do not want one of these judicial bodies settling a maritime boundary dispute. So they're allowed to exclude maritime boundaries disputes from compulsory settlement, and that is what, for example, Greece has done. It says it doesn't want ITLOS or the ICJ settling a maritime boundary dispute without its consent. Of course, the other issue of consent in relation to maritime boundary delimitation is that not all states, for example, in the Eastern Mediterranean region, are parties to the United Nations Convention on the Law of the Sea. And this means that, for example, they could not be brought to ITLOS in Hamburg without their consent. Because ITLOS was created under the Convention of the Law of the Sea, so for a non-state party to the convention to come here, they would need to consent in advance. Whereas the ICJ in The Hague was created under the UN Charter, so it's open. All states who are members of the UN are party to the statute of the ICJ. However, that doesn't mean you can automatically bring them to the ICJ. There is a procedure where they can give their consent in advance. But for example, Turkey has not given that consent in advance. So if you want to bring a case with Turkey to the ICJ, you have to have the agreement of Turkey. And just in terms of what those two permanent bodies, they're pretty similar in how they function. ITLOS here has more judges, 21 judges, but states can choose if they want to have their dispute heard by a smaller chamber. At the moment, we have a case between Mauritius and Maldives, and in this case, the parties chose a chamber of 9 judges that they wanted to hear their dispute. And they reached agreement with the help of the president as to who those judges should be. Before both bodies, if a state doesn't have a judge of its nationality on the bench, it has the right to appoint a judge ad hoc. So that's a judge that it nominates specifically to sit on the bench for the specific dispute. At the moment, there is, for example, a judge from Lebanon on the bench of the ICJ. But if, for example, Lebanon and Turkey were to agree to go to the ICJ, Turkey would have the right to nominate its own judge to sit on the bench. Another difference between the ICJ and The Hague is that, the ICJ and ITLOS. So ITLOS under the Law of the Sea Convention can only deal with Law of the Sea disputes, Whereas the ICJ, because it's under the UN Charter, it can deal with other questions of international law, including questions of territorial sovereignty. So who is entitled to exercise control over land territory? And this is often a first step in maritime delimitation, because it is land territory that creates the entitlement to the sea. So for example, in the Colombia-Nicaragua case before the ICJ first determined who had sovereignty over certain islands, and then at this next stage, it proceeded to delimit the boundary between those islands and the mainland of Nicaragua. Before both courts and before the ad hoc body Annex 7 tribunals, the procedure is pretty similar. There's a written phase and then there's an oral phase. The written proceedings, there's normally 2 rounds, so each party makes 2 written submissions. The timelines for this are longer before the ICJ. Here at ITLOS, we give slightly shorter timelines for those. And then there's an oral hearing where the parties present their arguments, and then the judges deliberate. And again, there's a slightly quicker procedure here at ITLOS. Normally the decision is issued about 6 months after the oral hearing. So there's an example. We, a few years ago, dealt with a maritime delimitation case between Ghana and Cote d'Ivoire here at ITLOS. That case was submitted to us in December 2014. And the decision came out in September 2017. And that was considered a relatively quick process because we also had an interim order request from Cote d'Ivoire, which I will describe in a minute. But it's not a quick process for states. And I think that, you know, they need to be aware of that. But often, you know, if negotiations have stalled, it's a better option to go through. And sometimes states continue to negotiate in parallel while they're litigating a case before international courts or tribunals. And as I mentioned, the law applied is also quite consistent between all of these bodies. It's the 3-step approach where they start with an equidistance line, then they adjust for relevant circumstances, particularly circumstances related to coastal geography, such as the shape of the coastline or the length of the coastlines. And then they finally, at the end, they check whether a proportionate effect has been achieved. And I should mention there's a final option for states under the convention, and that is conciliation. Conciliation under the convention is a non-binding procedure where the Conciliation Commission issues recommendations on how the states should approach the delimitation. And this was used for the first time by Australia and Timor-Leste. They constituted the commission in 2016, and they reached an agreement in September 2017 on the boundaries and certain oil and gas fields. And then the states, on the basis of the recommendations, signed a new maritime boundary treaty. The difference is that that treaty was not drawn by the Commission, it was drawn by the parties on the basis of the Commission's recommendations. And that has been seen as a great success by law of the sea practitioners, and I think it's an interesting option for states. The last thing I just wanted to mention was what happens. So let's say this delimitation by a court or tribunal takes 4 years. Are there any rules that apply while states are waiting to get the answer to where the line should be in accordance with international law? So under the convention, under 2 articles of the convention, there's a rule that in the EZ and continental shelf, while states are waiting or pending an agreement, they should make every effort to enter into provisional arrangements of a practical nature and not to jeopardize or hamper the reaching of a final agreement. So when it says provisional arrangements of a practical nature, here you have things like joint development agreements. An example is one that was created between Nigeria and Sao Tome and Principe. They wanted to develop the hydrocarbons in the region, but they couldn't decide on where the boundary should be. So they created a joint zone, and there was a 60-40 split of the proceeds or profits from this zone or of the oil, 60% to Nigeria and 40% to Sao Tome and Principe. And you also have these kind of agreements for joint fishing zones, or you have states just agree that neither state can do anything in the zone pending delimitation. So this, as I mentioned, is a rule of UNCLOS. And it has been suggested that it's customary international law and would apply even to non-state parties, but there hasn't been any judicial pronouncement to that effect. So it's difficult to conclude 100% that you could say, for example, that Turkey is bound by this obligation. However, I think you can definitely say that there is an obligation under international law not to aggravate a dispute. So even if you are not obliged, for example, to negotiate on a provisional arrangement of a practical nature, it's clear that under international law, you should not act in a way that aggravates an existing dispute. And the last thing I wanted to mention was that for states that have brought their delimitation to a court or tribunal, and they know that that's going to take maybe 3 or 4 years or more, they can apply, if there's an urgent matter, they can apply to that court or tribunal for provisional measures. So for example, in the Ghana Cote d'Ivoire case, there was a disputed area between the two states, very rich in hydrocarbons, and drilling was continuing in the area. And Cote d'Ivoire applied to ITLOS in Hamburg, and they asked for an order that Ghana should be prevented from any new drilling in the area until the final delimitation was achieved. Now, in that case, ITLOS said Ghana could not do any new drilling, but it was allowed to continue existing drilling in the disputed area. And that might sound a little surprising, but it should be understood in the context of the case where, firstly, the parties had for many years more or less been drilling along a de facto line. And there were environmental concerns where that if active oil wells were left unattended for several years, that there could be a risk of environmental damage. So that's all I wanted to mention on obligations pending delimitation, and I'm happy to answer any questions on what we do here at the courts or tribunals.
Thank you so much, Dr. Burke, for those valuable insights. So I wanted to follow up on a question that also Mr. Baroudi has initiated earlier before moving to the discussion, and we have a lot of questions regarding what you have just mentioned. So I again call the attendees. If you have any questions, please do put them in the Q&A box and in the comment on Facebook, and I will try to raise them directly after this. So Dr. Burke, Rudy has mentioned earlier, and also we know that over like a year from now, or since November 2019, we have heard about 3, if you want, maritime agreements. So Turkey and Libya in November 2019 have agreed or have signed. They announced the signature of a maritime agreement between in the East Mediterranean. Then Greece and Italy have signed in June later on an agreement based on the coordinates signed earlier in 1977. And after that, on August 6th, Egypt and Greece have also signed another agreement delineating their maritime boundaries. My question is, when such agreements, or when we hear about such agreements, do they mean anything from an International Court of Justice perspective, or and what if we need to make those agreements official? What are the steps needed for the countries, signatories, if you want, signatories countries, to make them official? So when such agreements are made, do they mean anything from an ITCLOS maybe in perspective, or International Court of Justice perspective?
So if 2 states come to an agreement on the split of their maritime zones, and that meets the requirements, for example, it's in written form, it's signed by representatives of the state who have the power to bind the state, then it is a binding international agreement between those 2 states. And I mentioned that this obligation of registration, so they would need to register that agreement with the UN, and then they could rely on that before the International Court of Justice. But I guess, that's a question between those 2 states. So if, for example, there was a case where a 3rd state came to the ICJ, and you're wondering what is the legal effect of a boundary between 2 other states? Well, the 3rd state is not bound by that agreement. If it has an overlapping entitlement, the fact that 2 other states have divided up some of its entitlements will not bind that 3rd state. So does that answer the question, or was there another part of it?
Yes, absolutely less. So I have another question for you from the one of the attendees, but it's mainly more specific to the Turkish case. Maybe we can raise it now in the Q&A session. So let me start going back again to Dr. Elinas, and we have a question from Mr. Furkan Guldemir. He's asking to Mr. Shar Elinas, how should we approach the 2004 Cypriot Annan Plan referendums in the context of gas drill activities of Turkey in the East Med? And subsequent to this, while military boats of the country sail in the East Med, do you know gas companies willing to participate in gas discovery projects, like knowing such disputes are ongoing? You are muted, Dr. Elinas, if you can unmute yourself.
I mean, the Annan Plan is history now. I can't really say much about it, and discussing it won't take us any further forward. But let's start with the very last one, the presence of warships in the area and the impact on the oil and gas companies. Certainly, the oil and gas companies are there to explore and find and produce oil and gas. They are not there to confront warships. So if their personnel safety is under question, they will withdraw. They will not carry on. They will not proceed. But in the parts, I mean, if we refer specifically to Cyprus, I mean, Egypt is, by the way, is completely different. There is no dispute. There is no, all the gas fields and oil fields are close to the Egyptian coast. And Egypt has a huge internal market, and it carries on developing these things. So let's leave Egypt out, because there are no issues to do with Egypt. The gas fields discovered so far south of Cyprus lie in areas not under dispute by Turkey. So the oil companies that operate in those areas can carry on and develop the gas fields and do more exploration if need be, because they don't fall in areas disputed by Turkey. But as I said before, I mean, are we talking about something totally futile? We seem to be spending so much time talking about gas and believing that we are going to get we're all going to become rich out of gas. And this expectation and belief is leading to a lot of problems. Disputes are built on the basis of what? On the basis of nothing. I mean, I'm not going to name names, but I was at a conference last year, and a colleague from a Turkish Cypriot colleague, and I had a discussion, and I convinced him that we shouldn't be fighting about gas when nobody wants our gas. We're not going to develop it. We're not going to export it. The markets are moving away from us. So he agreed with me, but then he turned back to me and he said, but what if? And back we go again. So this gas is causing us so many problems, but there is little justification for it. We are not going to become rich out of gas. And that's why in one of my slides, I refer to the European Union, because the European Union in effect is exacerbating these problems by supporting, for example, the East Med gas pipeline. They are prolonging the problems. The European Union, it's not going to invest in the pipeline. They don't need the gas. We should stop these things, concentrate on resolving problems. That's why I was quite happy to listen to Rudy and his suggestion and his work and research to resolve the problems, not necessarily with that reference to gas. And happy to hear Naomi giving us the tools to resolve these problems away from gas. Gas is not the solution, not even the outcome of solutions, because there is not that much value, except perhaps for regional use. But then if we want to use it regionally, we need to resolve our problems. So hence back again to this problem resolution.
To the dispute, yes. So following up on that, I have another question for you, Dr. Elinas, because it tackles the coalitions that we have been hearing about in the East Mediterranean, like specifically the East Mediterranean Gas Forum, and what has been said regarding the East Med pipeline and the coalitions and the agreements signed over the past 2 years. So on this, Mr. Cyril Wederhoeven ask you, what will be the option of including Lebanon in the EMGF? Also, where are the commercials for these operations, as the current market is not supporting all, as you have just mentioned? At the same time, would energy be a main instrument to have the region integrate on the same basis as the European Union for coal and steel, precursor of the EU?
Yeah, I mean, the East Med Gas Forum, EMGF, could become the vehicle to unite the countries of the region. At the moment, it doesn't include Turkey, it doesn't include Lebanon, it doesn't include Syria. But it's open to all of them, provided these countries abide by the rules, by the regulations of the club. The club has some basic principles to which everybody needs to agree. If you have a club and you have principles and you want to join it, you have to agree. You cannot go and say, okay, no, you have to change everything for me to join you. I want to be in the club, but I want it to be under my terms, not your terms. It won't work. So for Lebanon, I think it's a lot easier. If the negotiations with Israel that look a little bit more promising now than in the past succeed, then there is nothing holding Lebanon to join. Syria doesn't come into it. Turkey needs to join EMGF only if it agrees with the rules of the club. And if they accept referral of the case to courts, and the courts bring in a formula to resolve these problems, it opens the way for Turkey to join. But let me add clearly here, the East Med Gas Forum at the moment is just a talking show. It hasn't gone very far, it's not doing anything, it's not achieving anything, it's not producing anything, it's not making it any easier or any more difficult for any projects to happen. It's just the beginnings. But if what I said before, that once we resolve the disputes, we can use the gas together with renewable solar power in the region to generate power, electricity, energy for the region, then EMGF can be very helpful in facilitating cross-border infrastructure, pipelines and cables and whatever else needs to be done to join these countries. And as you probably know, there are two projects in Cyprus at the moment. There are both interconnectors to join Cyprus to Crete and Europe, but also to Israel and Egypt. These interconnectors eventually will be needed between all of the countries. For that to happen, EMGF can be very useful. The East Med Gas pipeline is just a myth that meant something about 10 years ago. It really doesn't mean anything anymore. It doesn't have a future. Europe, it's not going to accept any gas from the East Med Gas pipeline. It doesn't need any more gas. If you look at the European Commission's own studies, looking at the future gas demand in Europe as a result of the Green Deal and the 55% cut in emissions, they project that their own gas needs will come down by 25% by 2030 and by 75% by 2050. So we're on a downward path. Why would Europe then support the East Med Gas pipeline that to become commercially viable, the Europeans must be prepared to pay $8 plus per million BTU for the gas. They buy that from Russia at half the price. Why should they want to buy double the price gas and spare Russian gas? This day and age, it's not just politics that drives gas, it's also economics. Economics means that Europe needs less gas, cheap gas comes from Russia, so they stick to Russian gas. East-Med gas
Thank you.
has no
Thank you,
future.
Dr. Elinas. Mr. Baroudi, I have a lot of questions regarding the Lebanese case, so I will try to tackle as much as possible. One question is for you, did Lebanon, from Muna Sukariye, did Lebanon give weight to its own islands, such as Palm Island and Ramkin Island, when defining the limits of Lebanon's exclusive economic zone? So this is the one. And to follow up on it directly, you have another question from Nawea Nicola regarding the Hof line. What are the implications to the so-called Hof line, which offered Lebanon around 50-something%, 52 to 55% of its former minimalist claim? And since we are now going towards a new approach, a maximalist approach, where does the Hof line stand?
Well, first of all, I would like to thank Mona for her question. Lebanon could not have given weight for the southern small islets that we have. We have given the weight for the northern one, which is the Rabbits Island in the north. And that's why the northern borders, after doing the construction lines between Lebanon and Cyprus and Syria for a tri-junction point, our borders move north. It does not move south. For the second point,
the Hof line.
The Hof line. The audience may well appreciate that in the 90s there was no GPS, no GIS. In 2005, the GPS was already available. And the latest studies and the proposals from the State Department came to us with almost 52 to 58, then it went up to 54 to us, and 46 to the Israelis. What now do we have is that if we go back to the blue rock, which everybody now knows, which you can get from Google Earth, a map, when you take that point, it is a land terminus point that nobody can dispute. It's the same thing when you go for Turkey versus Greece. I just send you a map now if there is a questions for the maritime equidistance line. Like Dr. Berkey said, the maritime boundaries start with the land. The land terminus point is where everything starts. This is for example, yes, this is for example, 471 miles north from the tri-junction point down in the Aegean Sea that hits the land terminus point that is agreed internationally, plugged at the United Nations, and this is where the land terminus point between Greece and Turkey starts, and this is where all the commissions that they can have, or the judges, whether in Hamburg or at The Hague, they will start their study from here. So if we go back to Rasna Khora, what we have is a compelling case that we go. Now, when the Mr. Hof came, the proposal was not as detailed as it is now. Today, the imagery, the precision, and the science, and the equidistance line that we have is equal to none. In the past, prior to 1990, for example, Cyprus and Egypt, where they have a beautiful maritime boundary already signed, but what they have based themselves on is a very old UK Admiralty oceanographic maps. And I do not know if you know how they used to do that. They used to do that by the ship traveling through the coast and doing the lines. This is acceptable to friendly states. They have no problem. But I am sure right now, if they want to do a remapping, they both have more areas on both sides. So the Hof line was not up to date as it is now. And I am sure the army has the latest coordinate, the Lebanese army has the latest coordinate to win their negotiations and get much, much, much more of what Mr. Hof was suggesting. I think it was the time of the Prime Minister Mikati in 2011 or
11,
2012. Yes.
So, and I believe from this picture, like Mr. Baroudi, I think we have a similar case to what you're showing here on the screen between Syria and Lebanon as well. Like we have this Al-Nahr al-Kabir al-Janubi, and from which we can also put the land terminus point at the bottom or at the ending between the meeting point between this river and the sea, right?
Absolutely. And it is the same thing between Israel and Gaza and Egypt. It is just the same. Like Dr. Bob Herc said, the land terminus point is the basing point where you start in equidistance straight by the book of any maritime boundaries.
Thank you, Rudy. I will come back to you. There's a lot of questions for you, like coming over. I want to go back to Dr. Burke. We have a question for you from also Muna. It seems she's saying that it seems Lebanon is going to dispute giving the islet of Tikhalit effect on border delimitation. Would it be possible to clarify the effect of small inhabited islets on border delimitation and not on generating maritime zones, and how founded Lebanon's claim is? I'm not sure if you have heard me well.
Yeah, was that inhabited or uninhabited?
Uninhabited islets
yeah.
on border delimitation.
I would say just in general, courts and tribunals have dealt with small features near the boundary line in two ways. The first one is you just disregard them and you draw the median line only between the mainland coasts. And then if necessary, you go back at the second stage of the process and you might have to make some adjustments because of those small features, you know, enclaving them or otherwise adjusting the median line. The other approach is that you take every feature into account as a base point and you calculate an exactly strict equidistance line. I think, well, it obviously depends on the size of the feature and how close it is to the coast or the median line and things like that. But there is some practice that for very small features near the median line, they are just disregarded in the drawing of the median line and then maybe taken into account at the second stage of the approach instead. You could see that maybe in Romania, Ukraine at the ICJ treatment of Serpents Island, or in Bangladesh, Myanmar, here at ITLOS treatment of St. Martin's Island.
Okay, great. A follow-up on that from Hari Barke. He's asking you as well. Turkey claims islands do not have right to EEZ, and that is continental shelf. Hence, it draws on its EEZ close to Cyprus. So is Turkey right in this approach? I think we have tackled this earlier, but if you want to say anything or to add to it.
Because I work at an international body, I don't want to say that any state is right or wrong in their approach, but I think what I can say is that the regime of islands is dealt with under Article 121 of the Convention. Turkey is obviously not a party to the Convention, so then the question is, does Article 121 constitute a rule of customary international law that would be binding on non-state parties? And if it does constitute a rule of customary international law, can we consider that Turkey, through its actions, is a persistent objector, such as to preclude the application of that rule to it? But I won't give a conclusion to those questions, if that's okay.
Based on your, for sure, but based on your presentation and the slides, so in case Turkey would need to abide by that, we need to get the consent of Turkey on the law first, because it's not a signatory on the agreement, right?
And for Turkey, you know, that would be the advantage of doing a bilateral negotiation. They might be able to get some kind of unique solution, whereas for Turkey, if they go to an international court or tribunal, that court or tribunal will be applying the international law of the sea Although, of course, they could take into account if Turkey said that it was a persistent objector to that particular regime, they would consider that argument.
Mr. Baroudi, again, a question from Karina Radler. So she's asking you, can the recently implemented de-escalation mechanism by the NATO prove its validity as an important and still essential alliance? And to follow up on what Dr. Elinas has mentioned regarding the EU, so after the NATO, your intervention on the NATO, what do you think should be the role of the EU as well in this regard when it comes to the Turkey and Greece dispute?
Question to me?
Yes.
Okay. Well, first of all, Turkey and Greece, they are both of them two founding members of the UN. This is one. Two, they are NATO allies. Three, they have 6 pacts that they have signed in the Euromed since Trieste and Barcelona. They are partners. They are commercial partners. So the NATO meetings is one of the platforms to de-escalate, and they meet every day. So NATO is a platform, but the UN is the main mother of all. If you want to go by the book, you have a dispute with a neighbor that you have had 4 or 5 times the last 300 years. You have had 4 wars. Why do we need a 5th war today, guys? Why? There is a book, there is the UN, and you are obliged by the United Nations Charter to find the best amicable and peaceful solution for any problem that you have. The EastMed does the same thing. The Union for the Mediterranean says the same thing. Now, I am sure there is nothing wrong if the White House or the State Department will assist them more to come together, regardless who is going to be the resident in the White House in 8-9 days' time. They have, the United States government, they have the moral obligation to bring 2 neighbors, friendly neighbors, NATO allies on the same table and sign peace. We need to handshake. We don't need wars. I cannot hear them.
Mark, sorry, I think you're on mute.
Yes, sorry. Thanks, Rudy. To follow up on that, you have a question from Mr. Fuad Jawad. He's saying how Lebanon proceeded to maritime southern disputed area negotiation without having a seismic or geologic data on that particular very sensitive area where the other negotiating party has done for sure all the necessary studies. I'm not sure about this, if you can answer it, or we can later on send it via writing.
I can.
Go ahead.
Dr. Fuad Jawad, hi. I hope you are doing well in Houston. It's very simple, Fuad. They would not let us fly over that zone. But today, the mechanism, without having boots on the grounds, we can have and we can buy commercial satellite pictures that are 40 centimeters. But you have also to have the allowance and the permit to buy this. Now, if they are there, if there is any misconception of any centimeter that exists there, they can both bring a drone with the UN assistance, fly it in there for 1 hour. It will give you a compelling, exact Ras Nakura point with an equidistance line. And Fuad, you should know that both parties, 8 years ago, they have put BP1, which is the #1 line from the LTP. They both started offshore, 34 meters for the Lebanese army, and the Israeli started at 24. So they both need go back to the Ras Nakura Blue Rock, and you have there. So your question is right. They need to have these high specs radars and all. But today, since they are there in one room, they can very easily do this. What we have assumed in the studies that we have done is basically going from the Ras Nagakura point that has been given and publicized by former retired General Amin Hutait. We took the latitude and the horizontal points that they have, and we build that according to the computers for an equidistance line, using the construction lines to Cyprus, using the construction lines from Cyprus to Israel, and then to us. So the precision is 100% sure.
Thank you, Rudy. I'll try to take a few more minutes from your time, like not more than 10 minutes, just to answer a few important questions, and then we'll wrap it up. And thank you for being generous on time. So two questions based on, to Dr. Elinas, based on your presentation and the numbers you have shown and in the slides. First, from Ahmed Tamar, he's asking you, how do you envision the intermittency of renewable without gas? And a second, from Mr. Antoine Kildani, he's asking about battery storage. So he's saying battery storage are becoming more efficient and prices on the kilowatt hour decreasing sharply. So do you think that gas will still play an important role in the energy mix by 2030?
Batteries, I mean, let's start with the last one and go to the first one after. Battery storage, yes, it's evolving and it's becoming cheaper, but it deals only with short periods at the moment. I mean, if the sun is not shining for a whole month, as it happened in Germany last year, and the wind is not blowing for a month, then batteries will not solve the problem. So they can go a long way, though, in minimizing the use, the need to have gas, or the need to use gas. But they cannot deal with that 100%. So you cannot have a situation over the next, I don't believe you can. I mean, the whole thing is evolving very fast, so you cannot say with certainty that nothing is going to be available in 10 years' time. But from what we know now, over the 10 years, batteries will not be sufficient. So at the end of the day, for the East Med, I believe the best way forward is a good combination of gas and renewables. Do away with coal, do away with oil, use the gas that we already have discovered in the East Med, and possibly more if we discover more, in combination with renewables to develop energy. But to do that, gas must be cheap. So we need to find ways to exploit and produce this gas cheaply at prices that are being demanded at the moment. It's very, very difficult. It's I see a minimal future for gas. But as a final point, if gas is going to be cheap, who is going to become rich out of it? You can't become rich by selling cheap gas. So there is a long way to go before we get to this situation, even using gas and renewables. It's who is going to invest in these projects? How is it going to happen? And are the governments of the region going to have the political will to actually make the switch? I see the problems in Cyprus. The political will to unlock renewables is not there yet. So it will take, I think these are valid questions, but they need to be debated over the next few years. But before we get there, we need to resolve our problems.
Exactly. So two final questions, and I'll try to take them equitably. One for both for Mr. Baroudi. One regarding the Greek-Cypriot conflict, and the other one on Lebanon, Israel, and then we can wrap it up. So there's a long note from Dr. Antonia Dimou from Greece for you, Mr. Baroudi. I'm happy, for the panelists, I mean, but I'm happy to share in writing later on. But quickly, she's asking, how can regional countries like Greece and Egypt overcome overcome Turkey's selective interpretation of international law? Is reference to the Court of Permanent Arbitration a preferred option to settle maritime difference with Turkey, or should regional countries continue to develop their resources and exclude Ankara from the unfolding architecture, energy architecture? So this is one question that you'd like Rudy to answer that, and then I follow it up with something on Lebanon as well. You're muted, if you can unmute yourself.
Thanks for the question. For Dr. Antonia, I would like to mention, first of all, I am Lebanese, I am Mediterranean, and we have worked a lot to have the Euromed there. To exclude Turkey or not to exclude Turkey, I would like to have a union for the entire region where we can all live in peace and prosperity. Like Dr. Elelina said, there is no more any room to export this gas. It's going to be for local, which we need, and the regional, which we need. And this is where we are going to get the cash in order to pay schooling, social, electricity, social welfare, etc. Now, the Greek Cypriot and their Turkish neighbors in the north, there is a strong will for both sides to unite. I believe, I might be wrong, I believe if the true leaders of Greece and Turkey can settle through the International Court of Justice or through the United Nations or through the White House assistance, the Greek Cypriot and the Turkish Cypriot problem will be already diluted. Already the Turks are getting their water, their passports, their social welfare, or already they are part of the island. So the unification there is also a big plus and a big win for all of the region. It is not just for us. We neighbors, once we go, it is hard for us to see a small island divided. We hope and we should pray for a unification there.
Thank you, Rudy. Quickly, on Lebanon's case, from Noé Nicolas, the question is based on what you have mentioned earlier regarding the 80% approach, and that our right is to have at least 80% and even sometimes more. The question is, the maximalist claim, which Lebanon is now following, also with the negotiating team, giving the readiness of the relative case law, are there indeed any precedents that could support Lebanon's maximalist claim, or at least somehow more than the current minimalist claim, rather than even less than the 55% or the 52-48? And she is giving the example of Nicaragua versus Costa Rica comes to mind, but as one example. So the question, just briefly, are there any precedents that we could build up the Lebanon's case on to follow with the approach of 80% and even more?
Well, if we go back to the principle of the United Nations law of the sea, the maritime boundaries start from an LTP, land terminus point. This is already a sealed thing. It's a place thing. It is signed. It is there. And if you go by the book for an equidistance line, pure equidistance line, we are not talking about this. Let us say it's country A versus country B. And we go through this line, taking into account the small islets or islands or whatever that you can have. Facing us, we have Cyprus. We can get much more with today's science and today's law, much more than the 52, 55, or 58% that is being discussed, and we will not lose. We are coming into these negotiations to win over the Israelis' claim by law. With science and law, we are going to take maybe all of the zone, but let us say much more than 80%. We will defeat everybody by law and take our rights. That's our rights. It is not a thing that is for Naomi or Charles or by book. You go through this. There has been thousands and thousands of construction lines that have been built by computers to draw the construction lines between the land terminus point in Rasna Khura to Cyprus and then back, from Cyprus to Israel and then back, and then they will have an equidistance line. Now, to be more, to confirm that, I am sure the task force will ask for an authorization for a drone that you can use and fly it there for an hour and get the precision to reconfirm what the army has. The army has all of the data. They have done their excellent job, and inshallah we should win there. And as soon as we do this, we have to go to Charles A. Linas in Cyprus to sign the delineation there. We have 96 miles that have been waiting since he was, the boss there for 15 years. We have a line with no problems there. And we could have a joint development fields with Cyprus, any Total and Novatec. They are there and they are here. So why do we really need to reinvent the wheel? Exactly. So let's do that.
Exactly. So we cannot but re-echo this final note and this final intervention, like to support and to abide by the science and law, to support the Lebanese negotiating team now to keep Lebanon's rights. So with this being said, I would like to thank you very much for your, first for your time, for your patience, and for your active participation in this panel. Dr. Berg, thank you for your insights. We know how busy you are in the court, but we thank you for the time and for your generosity on this. And
thank you for having me.
Yes, Dr. Elinas, thank you so much as well for your insights. Mr. Baroudi, it's really always happy to have you. So we look forward for future discussions on that, and you're always welcome on the IFI's platform. Thank you so much.
My pleasure.
Thank you. Thank you.
Ciao.